This program is brought to you by Emory University.
Good morning. We're going to go ahead and get started. We're actually running a little behind. As a result, I'm going to refer you to the bios for my panel. But I want to tell you a little bit about why we have these three on the panel. George had a very successful practice, was partner in a law firm, and then moved to teach, and he's been at the University of Tennessee. Connell did an entire career in-house. She was one of those unusual people who went straight from law school to in-house, and she was in-house at several companies and has retired and has been an adjunct since she moved to Atlanta, or shortly after she moved to Atlanta, and has developed a couple of courses here at Emory. And then Dennis has done the more traditional of going from basically through the more traditional academic ranks and is dean at Western Kentucky University. So we've got these three for this perspective of a continued conversation of the theme of this conference, from doctrine to practice. Yesterday, I think we had great discussions and great conversations about from doctrine to practice in a lot of detail and with a great sense of mission, and including in our honoring Tina last night. I think we were, in talking about Tina's developments and Tina's career, we're talking about the very essence of what we need to do to go from doctrine to practice. So after last night, several of us were saying, well, what's left to say today? I think we have a lot left to say, and we need to keep this conversation going. But today, so that we don't just kind of hammer on exactly the same things, one of the things we want to do is think from doctrine to practice and a little bit beyond. Instead of just thinking about how do we get our people to be able to hit the ground running on the first day, and that will be part of our discussion. One of the things that we've been talking about is when you ask a transactional lawyer about what does that lawyer enjoy, what does that lawyer think he or she adds value to, you often hear the words trusted advisor. One of the goals, one of the satisfactions of being a transactional lawyer with some experience is to become that trusted advisor, that person who can integrate the practice, the skills, the client skills with the knowledge of the law and the application of the law, and that judgment, that ability to advise. So as we talk about from doctrine to practice, today we're going to focus on really three different areas. And then I have asked each of the panelists to come up with one thing to sort of as a charge to us as to things we might want to accomplish before we meet again in 2014. They have not told me what that thing is, and so we will all be surprised when they tell us what that one thing is. But in these first three areas, we're going to kind of parse this. We're going to talk about from practice to doctrine, because we have this here on the panel. We're going to talk about from from practice to the classroom. And we're also going to talk about from doctrine and practice to professionalism, and hope that we come up with a little bit more of the picture of not only how do we develop our students to get to that first day very successfully, but how to continue that career very successfully. So, grab this. Our first question is, from practice to doctrine. And when I threw that out on the phone last week, we almost continued on the phone until our time ran out. But I'm going to ask George to lead us off, having gone from practice to doctrine and a combination back. What do you have to say for us?
Okay, well, I'm not sure there is all that much that is new to say after the great discussions that were had yesterday. There may be different ways to spin it and to connect the thoughts, and so let me try with that as a goal in mind. I think that the summary of what I was hearing, especially at last night's dinner, was that we are entering an era where law graduates are going to be required by the marketplace to be increasingly specialized and possessing an integrated set of substance and skills as they graduate so that they're, quote, ready to practice. Now, thinking about that, I'd like to put out on the table a couple of thoughts about how we might get there. And some of these are well, they may be foolish and radical thoughts, and I'm perfectly happy to have you call me a fool or a radical. I probably prefer the second. The first thing to ask is, what does ready to practice mean? Sounds great. It has sounded great since at least the 1990s. As legal writing and research programs took off and really started to try and produce people who could at least write office memos and maybe basic pleadings going forward. But there are some structural items that I think we have to attain or achieve in order to attain something that really can be called ready for practice. Because most of the folks that I graduate from the University of Tennessee are not people that, in the words of one of our adjuncts, you would want to send out on a deposition on the first day of practice and then have them handle a jury trial next week. That's somewhat of an unrealistic goal. I suggest that, however, in response, that, but within 3 months, they ought to be able to go and take a deposition. I know I took my first deposition when I was 2 months out, and I was told what to go and get, what questions to ask, and what subject matter areas to probe. And I reviewed the rules of evidence, and I went and did it, and I didn't do a great job, but I got everything I needed to get, and I came back, and I learned something from it. Similarly, on the transactional end, I was thrown into a transaction involving a piece of a large hardware store conglomerate that was being acquired in a Chapter 11 case. And we had to handle the due diligence on a bunch of franchisee agreements and how those came together. That would have been within 8 months. My time was billed and collected. It was a bankruptcy case, so I got to see that it was billed and collected and approved by a bankruptcy judge. So I guess that was ready to practice too. Was I a brilliant transactional lawyer at the time? I doubt even if I'm a brilliant transactional lawyer now. But it was successful. I think there are some things that we can achieve in the academy. The first is to pull back the learning that has traditionally been expected in the first or second year of the firm experience into the third and maybe even the second year of law school. I think that's what a lot of the coursework that was the subject of panel discussions yesterday is really aiming to do, is to get it more real, sooner, and faster. To a certain extent, the sooner you plunge the students into the deep end of the pool and stand there with a net to pull them out if they're about to drown, the faster they learn to swim. And our goal really is ready to practice, ready to swim. Second, I think we need to look at our admissions criteria. The business schools for years have been trying to turn out people who are ready to be business people from day one, hitting the ground running and being successful. And as a result, they've adjusted their admissions criteria to make sure that they give a preference, a very strong preference, to people with at least 2 to 4 years of actual work experience. Anybody who has taught mixed classes of law students knows that there is a profound difference between students who have 2 to 4 years of actual full-time work experience or even juggling multiple jobs during their college years, and those that have gone straight through without that experience. The ones with the work experience are faster, more efficient learners. They understand what a 40 to 50 to 60-hour week is. In general, these are all broad generalizations, but they're based upon my experience at 12 years at the University of Tennessee and another 10 years before that adjuncting at both Hastings and Cal Western. So we really ought to think about that. And in fact, I think at UT, I'm the chair of the admissions committee, and we do put a lot of stock into those kinds of pre-law school, post-undergraduate experiences. I think we also have to really think about staffing our classes with teachers with appropriate experience and a deep experience. sort of in a trite phrase, I think legal education is too important to be left to traditional doctrinal law professors. It's not that they don't have a role in it, but that type shouldn't occupy the entire field of what our students are exposed to. There's a saying going around in some research that it takes 10,000 hours or so of working at something to become an expert in it. I would suggest that one way of assessing suitability of folks who want to produce ready for practice associates is to have people who've got about 10,000 or 5 years at a 2,000-hour a year worth of experience after law school, either in clerking experiences or for law firms, government agencies, whatnot. There is a difference. If you've ever worked in a law firm and trained and worked with young associates, you know that there's a break point between 4 and 6 years out when suddenly they become really responsible and really able to act as foreman on a job and take more work off your plate than they generate by putting it back on your plate. I think we also need to develop ways to co-teach and push partnerships of doctrinal faculty with practice-based faculty, be they full-time or adjunct-based. And that team teaching takes more coordination than the academy is used to displaying in some cases. A lot of people are very used to, I know I work up what I'm going to do in my Contracts 1 class and walk in and do my show, and I don't have to pre-clear it with anybody else. That's a freedom that may have to be somewhat modified in order to make it more effective of a course. I think there ought to be some alternatives to the independent adjunct model, where we take a course, we turn it over to an adjunct professor. Most of the time, unlike Tina's experience, we don't have a doctrinal professor sit in and watch every class. In fact, just the opposite is true. You may have 1 or 2 doctrinal faculty who drop in for a visit in the first few years, and then if the teaching evaluations don't show any blips, if every number is above a 3 or so, they're let to go on their way. I think there can be, again, more of an integration of those adjuncts into mainstream courses, and they can be brought into the curriculum as a whole rather than as just an appendage that's out here, however beneficial the appendage may be. I also think that it's going to be time for deans and associate deans and program directors to reach out to firms that hire within their area and say, okay, we get the message. We understand that you want more functionally trained associates to hire. We will be able to do that. We can use part of the 3rd year, maybe part of the 2nd year, in order to achieve that end. But we need your help. We can provide you the overhead expense. We've got a building, we've got lecterns, we've got seats, we've got lights, we've got heat. We have doctrinal faculty that are available here. But we need you to support us with adjunct support, guest speaker support, that in an organized fashion. And we need you to actually give some credit to the people who are doing that within your firm. And by this, I mean treat it like pro bono work. A good number of firms, including most of the ones that I worked for, would count pro bono hours. Now, did they really count like a full hour towards your 2,000 billable hours a year? I can see some people smiling. They were an affirmative defense, but if you got to 2,200 and you had 150 of pro bono on there, that was a good thing. And I think that model probably is still somewhat pervasive out there. But let's have those folks come in. The benefits of that are huge. Number one, they know what they're doing in terms of the practice of law. Number two, they know the skills that they want to hire for the practice of law. Number three, it becomes a mentoring relationship which can stimulate everything from professionalism to just general business know-how of how things work. Number four, they can write excellent letters of recommendation. Not just the one-off letter of rec that says, Billy Johnson was in my contracts class, did very well and attended and was frequently participating. That doesn't do you any good. We can talk about how they've achieved certain projects that they've worked with the adjunct or visitor on, and get into real specifics that demonstrate that the candidate is ready for practice, or at least some version of ready to practice. I guess the only other thing that I'll add, and this is, it ties in here somehow, and I'm not sure how it does, but it does. There's an increase in a phenomena that I've seen, at least in our market, which is not primarily the mega firm market at the University of Tennessee, although we do place some folks there. We're regional mid-sized firms all the way down to small firms of 5 to 10 lawyers. The increase of the practice of law being practiced as if it was a neural network of independent actors or semi-independent actors is something that is that's increasing. Technology has made the ability to communicate over vast distances quickly and transparently. It made it possible for networks of attorneys to form and to band together for a certain particular project, transactional or litigation, and then disband, and each one is covering their own overhead. The plaintiff's bar is perhaps the best example of this for a long time now, bringing in as many plaintiffs litigators to organize cases in mass torts and the like. But it's spreading onto the business side. I know it's spreading onto the reorganization side because I get calls from people who are involved in that kind of thing. So it's moving, and our students need to be prepared for a business model that may include them being rather entrepreneurial service providers of limited scope within a constantly shifting team of service providers. So those are the first thoughts I have as to how we move this forward. And I can't emphasize enough that the B-School model, and I'll confess I have an MBA that I went back for and found that the skills that I got were excellent, and the vocabulary that I got and my ability to talk to business people vastly improved. And I used less Latin afterwards. So that's something I think we ought to take a look at. We should look at what's been successful for other disciplines that impact on the business world and see if we can't take a clue from that.
May I interrupt just to say, let's, if we can focus on some of these things, if Jan could talk a little bit as from the perspective of being a client, since you were in-house, and especially to get the dean's reaction to some of these things.
Picking up on some things that George said and focusing, as Carol said, on having been the in-house counsel, and also I am a mere adjunct here. So I have those two perspectives of what it is to have been a client, to have been an in-house counsel, and hopefully the trusted advisor, and then turning those experiences into a teaching experience as an adjunct professor. And I think one of the difficult things, or maybe not so difficult, but at the inception is to determine what does it mean to be a trusted advisor. So before we can even determine what it is we're going to try to teach these students or what kind of program we're going to develop to turn out trusted advisors, what does that mean? As an in-house person, put quite simply, it means people actually want to talk to me as opposed to, oh my God, we've got to run it past the lawyer, which is what happens quite often in the in-house world. And so it is a real uphill battle to become that one of the business gang, one of the people that becomes part of the team because people want you to be part of the team, not because they have to put you on their team. So what does it take to get there? It primarily takes the ability to speak the speak, to move out of what you have been so trained to do, which is to talk like a lawyer. And instead of talking like a lawyer, rather to learn to listen like a lawyer and talk like a business person. And as an adjunct, my task was to figure out how to do that and to break down this concept into components that can be taught. I will tell you that as an adjunct who's always been a practitioner, that's so much easier said than done. What are those components? And I would propose that those components, are very basic. We're talking about simply the ability to get enough information that you can actually be useful on any given issue. To give you an example, and this is, I'm sure, anybody who has practiced has had this experience. You start with maybe reviewing a contract. You know kind of what the transaction is, that we're going to license this piece of IP. Okay, great. Here's the form contract we've always worked with. You look at it, you get a little bit of information from the business people, and the first thing you do is you go back to the business people and you say, we can't do this. And you really don't have a good reason for why you can't do it, but your reason is because, well, there's risk here, there's risk there. If we do this, we'll be exposed for da-da-da-da-da. And not realizing as the practitioner that that's not your job to say you cannot do this. Our job is to identify risk and to say, how can we do this? But in order to do that, the lawyer has to understand the most basic principles of communication. So one of the things that we have done, and I think is helpful, is to incorporate some really basic communication skills into our substantive classes. To use deal skills as an example, right at the outset, we start with a very simple client meeting, the goal of which is to, for half the class, the goal is to help the client sell a small, closely held business. The other half, of course, is to help a client purchase a small, closely held business. And in order to do that, they have an initial meeting with a client. The client is an older gentleman who wants to retire. He wants to sell the business. He's divorced. He's got a love interest in another state. He wants to get out. The wife has a little bit of an ownership in the business. Oh, and by the way, he's not quite 65. He's got a few years to go, so he doesn't have any health insurance. And oh, by the way, he's got some real health issues that may prohibit him from getting private insurance. And this is the basic fact pattern that the students are dumped into. The senior partner has to flee or can't get back into town, and this young associate has to interview this witness. Typically, what they get is, well, how much money do you want for this? When do you want this to take place? What, the sort of basics of what you might be putting into a contract. The goal here is for them to learn to go way beyond exactly what you might see in a form contract I work with, but to understand their client, to understand what is motivating the client. And some very important issues come out of some of this background that could affect a sale of a business, which you don't want to find out toward the end. What will happen after I sell this business? Will I be able to have health insurance? Oh, by the way, I don't own 100% of the stock. My wife has an interest in it pursuant to a divorce decree, and so forth. So there are built-in things in a problem that a student has to find out, and so they have to learn to just talk, to just ask some open-ended questions, to listen to what is behind the question and the answer that has been received. That's pretty basic, but I think that's a skill set that young lawyers or law students or that we're turning out don't necessarily have. And so the next step is, as an adjunct or anyone, how do you teach that? How do you develop these situations or scenarios where you can teach those skills? I would suggest that these are the types of skills that need to start not necessarily in a contract drafting class or in a deal skills class or a corporate counsel class, as I have taught, but these are skills that could be integrated very early on, and I think we overlook some really, really basic skills. I'll pass it on now.
Well, I have to start off by making a confession, and that is that, as Carol indicated, I am not a deal lawyer. I'm not a transactional lawyer. I did stay at the Emory Conference Inn Hotel last night, though, so I'm ready to talk. And I also have to say I'm from Northern Kentucky, not Western Kentucky. My president would shoot me if I didn't say that. You know, from a dean standpoint, I've sort of been playing with this for a long time. I think my first iteration of this is in '96 when we were at Western State and sort of cutting edge at the time, and we started an entrepreneurship law center, and then I went to Washburn in 2001 as the dean, and we started the Transactional Law Center there, and I had the opportunity to work with some extraordinary people, Janet Thompson-Jackson, who many of you know, who runs the clinic there, Brad Borden, who teaches tax now at Brooklyn, and Rob Ree, who many of you heard last night, who's got a tremendous book in accounting, and I highly recommend it to you. It was a really super group. And then I've moved over now to Northern Kentucky, and we now have a transactional law practice center, and we've been able to bring in some very good people, including two stellar recent hires, Barbara Wagner and Eric Alden, both of whom are in the audience. So I've had an opportunity to try and build these things, and yet we haven't been totally successful. And I want to suggest a little bit what are some of the barriers there very quickly, and I want to talk a little bit about professionalisms. The barriers are the ones that have been mentioned by a number of people, but just to reiterate quickly what I see is, first of all, many of the faculty are like me and have no prior practice experience whatsoever. We went to law school somehow for some other reason. I can't really articulate what my reason was, but we were at war in Southeast Asia at the time, so that might have had something to do with it. Of those who have experience, most of them have experience on the litigation side, so they're rich and deep on that side, but not on the transactional side. The second thing is, frankly, you just get some resistance from the academy. So many people have come from the litigation side that it just doesn't seem smart to be talking about transactions, and it's reputable to write about why courts do what they do, but it's not so reputable to write about or think about why organizations, particularly corporations, operate the way they do. That blends into a problem with workload. Teaching transactional laws, as George has indicated, can be very time-consuming. It's much easier to go in and pick up a book and teach them how to read cases. I mean, I think the traditional model of legal education has been we teach students how to read cases in the first year. Then we send them home for vacation. And you might wonder why we do that. At one time, we sent them home so they could harvest the crops. Now we send them home so that they can forget how to read a case, so that those of us who teach second-year courses can teach them how to read a case again. And then we send them home again after the second year and try to repeat the same problem. So in the third-year courses, we teach them how to read a case again. And one of the curious things is that if you test their case reading skills, they haven't improved much, which is sort of a weird phenomenon. But it does, if you're going to do this transactional teaching and co-teaching and the like, it takes a lot of time. And it's hard. It takes away from the things that the academy values and makes scholarship more difficult. It just takes some time. The other one that people don't tend to mention, but I want to, at least in my experience, there's resistance from students to some of this. I mean, we often talk about how eager and wonderfully satisfied and charged the students are, but I've run into a whole bunch of students who would much rather read a case in their second and third year because they know how to do that. They're comfortable with that setting. As horrible as it sounds, when we talk about it in legal education, they're comfortable with that model. They can sit back, they can read a case. It's not hard to both have the holding of the case and your eBay page open at the same time. And you can get through that. So we have to work with that. And I've had students tell me, I didn't take that course because it's too much work. Or it interferes with my work downtown, or it interferes with any of a number of things. So, those are some of the problems that you see, and I think that's just the beginning of them. Eric Gouvin's got a great piece that I think many of you may have seen that one about the barriers, and he does a far better job than I do on that. Now, how do you solve some of that stuff from a dean standpoint? Well, obviously, you hire for experience. And we've been doing that very successfully, and that's terrific. The second thing is, many of the folks in the law school that are, particularly our law school, but I think elsewhere, are really getting excited about this transactional teaching. They just don't know how to do it. Or more importantly, they don't, they will articulate the following: I used to know how to do that, but my skills have gone stale. That's usually the kind of I forgot to ride a bike argument because I've never been on a bike. And how do you solve that problem? I think we have to set up some ways for training people. I mean, training lawyers, law teachers, the nasty word in legal education today is redeployment. I mean, we have a lot of assets committed to, human capital assets committed to doing the litigation model, and we aren't going to be able to go out and hire another cadre of folks to supplement those. So what's going to have to happen is some people are going to have to move from teaching one way to teaching another way, and they need to do skills training. I am, for one, for example, would be willing to send any of our faculty members up to Harvard for the 2-week negotiation skill if they were going to teach negotiations. Now, it's easier for me to say that because I should admit I'm stepping down at the end of the dean, so at the end of this year, so all the promises I make are binding on my successor. But I think we really do need to do some training for faculty members who really want to get into this. The third thing, and I think this is directly relate to my background, we need to have some experiential training for law professors. We talk about how great it is to get the students out to see the offices work and how to be mentored and the whole bit. Well, if you haven't done this for a long time, or if you're like me, you've never done it, the question is, how do you get someone like me into a law firm to actually see a deal without embarrassing me? Because we have that same problem the students have. We want to be safe. We never stop being students as faculty members. And so providing safe havens, if you will, for faculty members can go and spend a semester in sabbatical in a law firm and observe. And those who have done it are very comfortable going back. Those who haven't done it, we need to figure out ways to get those people in so they can begin to do that redeployment. So those are kind of, I think, the big issues and what are the big issues going on. One of the big questions that I deal with is sort of the question of professional responsibility and ethics. As a dean, you get to go to a lot of many conferences, and I'm on some ABA stuff as well that does that, where we look at the whole question of professionalism and professional responsibility, particularly for transactional lawyers. And the one thing, if you take a look at most PR books, they're very skimpy on materials that are relevant for transactional lawyers. Much heavier on materials for litigation. And even if you do some things such as, I was looking at a professional responsibility book just before I came here. It had a chapter on ethics for transactional lawyers, and it started off with ethics and negotiations, and then the cases and material were all about settling a lawsuit, which is different from doing a deal with 4 parties, all of whom can walk. And so, there's just there's a connection problem there, and I think we need to have develop some materials to do that. The second thing, even if you do the rules, and you do them well in a class, I think we all have to recognize, and I think everyone in this room recognizes, rules are easy to learn. No big deal. And if you haven't learned them, you can look them up on the web really quickly. Learning how to use those rules, learning how to do it, isn't so easy. And the analogy I often talk to my students about and some of my colleagues is that I've been learning the rules of golf for years. You should see my knowledge of the rules of golf. How's my game? Well, at Washburn, they got me golf balls. It said Washburn Law on one side. On the other side, it says, if found, please return, postage guaranteed. It's a little bit of a comment. So how do we get people to actually get out and know what those rules, how to work with them? Well, one of them, obviously, and I think the best 2 ways are mentoring situations. If you can line students up with great mentors, there's nothing that beats that. They're not easy to do. It takes a lot of resources, and as a dean, you have to commit the resources. I think a lot of mentor programs fall apart because resources aren't committed, and there's just so many other things to do that I think if you want to, that it's easy to push it to the background, and you really need to do that. Obviously, the things that everyone here, or so many of you do here, getting people into transactional practice settings, the externships, clinics, and the like, fabulous way to teach ethics and professionalism. Professionalism, by the way, I'm describing as, I break that down. Professional responsibilities are the things you have to do or can't do. Professionalism are the things you should do, the kindergarten kind of rules, the ways you're supposed, you don't have to do this, but you should do this, and working with that. And then the last comment I would make here is, you've got to bring professionalism home, and I mean that at the law school level. One of the things that I think I see in students is they're all going to be professionals when they start practicing. They're not so hot right now. And I'll give you the classic example there is reporting up. They would never, ever let a lawyer who was incompetent, drunk, inebriated, on drugs, utterly, totally unprepared, represent a client, and they all tell me they would turn that person in. If they saw wrongdoing, they would turn that person in. But I can't do that to my colleague because if I do that, she'll get an F. Well, if you can't do that at law school where the consequence is getting an F and learning, you're not going to do it when in practice when the consequences is pulling a license. And I think that law schools really need to spend some time bringing ethics home into the law school setting. And I think that takes a whole faculty commitment. And I've worked with a number of faculty members, many of whom are very committed to this, others of whom would say, I think there was cheating, but I'm not going to really look hard. I once had a situation where a colleague, I told a colleague when I reviewed his paper that his student whom he'd given an A to had cheated. And he said, oh, what makes you think that? And I said, well, first of all, when you read the paper, it's 40 pages, and the first 20 pages sound like a Harvard Law Review article, and the last 20 pages sound like it's from American Law Reports. And he said, well, that could just be an incident. Maybe the first student just came up and started thinking. And I said, well, the other curious thing is the footnotes start over at the same point. To which his response is, well, I told you it was good material. That's why I gave it an A. You handled the discipline problem, Dean. I was associate dean at that school. So I think we really need to bring that home. And, so there are a couple of things. I've got my points. Maybe I'll save my points till later. But I think those are the sort of issues we're facing. And all the talk we have here, and I think we have an incredibly talented group of people who are doing tremendous work. We're a small part of the academy when it all plays out right now. And trying to get the rest of the world to come around to seeing it our way is not going to be easy, and we have to work really hard to do it. And I commend you all for your efforts because I know you're doing great stuff.
Thank you. I would love to keep asking them questions, but this has gone by very, very quickly, and hopefully we'll keep that dialogue. So I'm going to turn to, what do you want to give us as that charge as a group that hopefully we will be able to reconvene in 2014 and say we have made some progress on that point? Let me start with you, Dennis.
Well, actually, if you let me, I couldn't come up with one good idea, so I came up with 4 semi-good ideas, I think. First one is develop the mentorship program. If there's any one thing I think that would help develop professionalism in the school is develop a really strong mentorship program. The second one, and that's sort of personal on my part, is find the right dean. When you do dean searches, you really ought to look for folks who are committed to this. I'd like to think you don't have to be a transactional lawyer to be reasonably decent as a dean, but you have to find someone who's willing to look at scholarship and at practice differently, so I think that's important. The third one is sort of my pet, is that I need, as a dean, and I wish you could help me with this, to find a better public role model of a transactional lawyer than Tom in The Godfather. The Robert Duvall character is an incredible transactional lawyer who knows the business, knows things how to work, does preemptive law in a very strange setting, but does it well, and is sort of a model in some ways. But I think we probably can come up with a better model than that. And the last one, Carol, forgive me, but get involved in the Business Law Education Committee of the Business Law section. Carol and I have been chairs of that committee. The ABA has a committee for business law education that is really designed to both educate those of us in the academy, but also lawyers about the things we're doing and the way we can do stuff. And the interaction that I have found with the interaction between that section and all of the other sections in the business law section of those committees of the business law section provides incredibly fertile ground for scholarship, for thought-provoking materials, for assistance. And so I really encourage you, if you're not a member of that committee, please join.
Thank you. I'm going to move to Jan.
I think I would like to see a shift in law school teaching philosophically that would move from teaching our students to be the consummate risk identifier, but taking it further into being not just the risk identifier, but the risk solver, the problem solver, or at least suggester of problem solutions.
Okay, George.
Well, this is actually a great progression here. We've got the strategic on the end, represented by a dean, and we're moving down towards more and more of the tactical stuff. I will echo what's been said and say that it's got to be a focus on going beyond issue spotting across the curriculum. And I almost hate to use the words across the curriculum. What I mean is from the first day of law school in the first year. I think that it doesn't take too much structural change on the big macro level. And I also think that, at least from my perspective as a program director, big macro change is not something that I can achieve, what with the tenure system, what with the current system. We're going to have to wait for some attrition to provide the opportunity for change that's out there. But what we can do today is find ways to make it easy for faculty, and that's one of the key things. Whenever you want to change something, you make it easy for faculty to make that change, to incorporate practice-based problems across the curriculum in all courses, and increase the amount of mid-semester written work product that is evaluated and evaluated in a thoughtful fashion, and then promote group and teamwork, which has long been ignored in law school, to the point that law students are hostile to it. And yet group and teamwork is what it's all about once you get out there and are practicing law, especially transactional law.
Thank you. I think with your suggestions, we've taken our topic from doctrine to practice much further on the continuum into the future, but also back. I think where we've ended up is starting with day one of law school as opposed to day one of practice, and of extending far beyond. So I thank you, and I hope that that will keep us going. And we've made notes, and we'll try to remember these charges that we have for the next time. Our time is up, but I do want to give a couple of minutes, since we just have to move to the first floor, to see if there are any questions for the panel. Any questions? Well, then I definitely want to. Oh, you see one? Okay. Go ahead. Certainly.
Let me just grab that at the start. I think there's a lot of cross-fertilization potential between small business clinics, be they community development style clinics or entrepreneurial law style clinics, for-profit, not-for-profit, all of that. I think that clinics provide a perfect place to develop problems based upon case files, which can then be used and reused in doctrinal classes or simulation classes, so that you can leverage the educational yield from having provided that representation maybe 2 to 5 years ago. It can keep on teaching, and it provides a way for a clinical teacher to integrate themselves into a more standard doctrinal or simulation class without a lot of effort on that clinician's part, because clinicians are working hard. They have a schedule that looks much more like a full-time lawyer's, which means your schedule is not your own, and you are dragged in many directions. So finding a way to, again, make it easy for the clinician to share the experience and build it into a more traditional style class would be I think that's the big opportunity that I see there as at least the low-hanging fruit that ought to be grabbed first.
I mean, I would also say that first, there's incredible work going on in the clinics, and I do think there's really a strong linkage between the development of transactional law teaching and the development of the clinical wave. I think one of the ways to do this is to get a transactional law team together, to get all the folks who are teaching transactional law together in the same room and start talking. We've done a little bit of that at our school, and I know that some of my colleagues have, because of the conversations that have occurred mostly outside those meetings, but they're part of the same process, have volunteered to help in the clinic and get involved and provide some advice to come in as sort of counsel, if you will. But that's that beginning of crossover where you begin to start redeployment. Folks begin to say, okay, what I'm saying in the classroom actually makes some sense in real practice. And what you found in practice really makes some sense for me to do some more thinking about in my classroom setting, and I really encourage that conversation. I think you have to get that conversation going. If you stay in your own room, and that's the traditional, I think, faculty pattern in many ways, the sort of loner who stays late at night writing articles or whatever, if you can get people to start thinking and talking to one another, I think you can break that down. But clinic is a great way to start what I'm talking about, getting traditional teachers into the transactional setting.
Any other questions? Well, let's thank the panel again. Thank you very much.